5 seconds to go. Start. The aforesaid provision is categorical in stating that any limitation prescribed under Section 468 of CRPC can be overlooked if sufficient cause is made out in the facts and circumstances of the individual case in the interest of justice. The said provision, while trying to balance public interest in initiating criminal prosecutions, has been restricted to peculiarities of individual case while clothing the court with discretionary power. Such a discretion vested in the court ought to be a principled exercise wherein the facts and circumstances portrayed justify such an exercise. The intention of the aforesaid provision is to make the inquiry a question of fact and not of untrammeled discretion as to whether in a particular case the court should condone the delay. It is in this context that the High Court is bound to consider the facts of the present case concerning the modus of initiation of the case and other factors before considering the aspect of condonation of delay in terms of Section 473 of CRPC. The approach of the High Court of adjourning adjudication of the interim application seeking disclosure of documents cannot be appreciated. Ideally, the High Court ought to have considered the interim application before dealing with the limitation aspect. Initiation of criminal action in commercial transactions should take place with a lot of circumspection, and the courts ought to act as gatekeepers for the same. Initiating frivolous criminal actions against large corporations would give rise to adverse economic consequences for the country in the long run. Therefore, the regulator must be cautious in initiating such an action and carefully weigh each factor. In ordinary course, this court would have remanded the matter for adjudication by the High Court on the interim application moved by the appellant seeking such disclosure. However, arguments have been extensively advanced before this court touching upon important aspects of criminal jurisprudence which require consideration. Moreover, the facts stated above clearly indicate that the acts which are sought to be prosecuted go back to the year 1992 to 1994, and over 3 decades have passed without there being any end to the litigation. In this regard, the court intends to examine this important issue and pass appropriate orders to ensure that the adjudication is not delayed unnecessarily ad infinitum. This brings us to the issue as to whether the interim application seeking documents filed by the appellant herein deserves to be allowed in the instant case. The respondents have raised objections for such disclosure on 2 counts: that such a request was already rejected by the High Court in an earlier writ petition filed by the appellant herein when the settlement proceedings were ongoing; that the respondents claim legal privilege as against both the opinions of Justice Retired B.N. Shri Krishna and the report of the Chartered Accountant. Coming to the first objection, there is no gainsaying the fact that the respondent regulator had issued a letter dated 16th April 2010 conveying the findings of the investigation. In furtherance thereto, the appellant had sought to settle the issue considering the fact that substantial time had already elapsed. Stop.